Right, let's step straight through those heavy oak courtroom doors and get into it. Welcome to this premium legal explainer. Today, we're unpacking one of the absolute most critical frameworks in Indian criminal justice, Chapter 4 of the Bharatiya Sakshya Adhiniyam 2023. We're going to completely dissect the core mechanics of oral evidence, specifically looking at sections 54 and 55. Look, whether you're a practitioner prepping for a brutal cross-examination or a law student trying to nail down these statutes for your exams, understanding exactly how evidence is admitted and how a judge actually evaluates it is just absolutely fundamental. The words spoken from a witness box hold immense power, so let's figure out exactly how the law harnesses that power.
Here's our docket for today. We'll kick things off with an introduction to Chapter 4, dive into the general rules of Section 54, and then look at the strict direct evidence mandates in Section 55. After that, we'll navigate the tricky waters of hearsay and its exceptions, look at some heavy-hitting landmark judgments, and finally, wrap it all up with a quick, exam-focused summary.
All right, let's start with Part 1, an introduction to Chapter 4.
Moving right into Part 2, Section 54, oral evidence.
Think of the courtroom as a theater of facts. Chapter 4 of the BSA is basically the bedrock for how you prove those facts without dragging physical documents into the mix. It entirely governs the spoken word, the testimony of witnesses under oath, and Section 54 lays down the absolute baseline rule here. What's actually pretty wild is the sheer breadth of this rule. It's beautifully simple. All facts, except the contents of documents, may be proved by oral evidence. That literally means as long as the fact you're trying to establish isn't tied to the specific text written inside a document, a witness can just stand up in the box and testify about it verbally. The law recognizes that real life happens out loud, out in the open, and human testimony is our best vehicle for capturing that.
Let's picture a quick courtroom reenactment to make this crystal clear. Imagine Person A is accused of physically attacking Person B. Can you prove this using oral evidence? Absolutely, 100%. An eyewitness taking the stand and verbally describing the assault is totally admissible under Section 54. That's a perfect example of what can be proved. But imagine a totally different scenario. Let's say Person A and Person B are arguing over the specific interest rate written into a physical, signed contract. In this case, an eyewitness cannot just walk up and verbally tell the court what they think the contract says. Because the dispute is over the contents of a document, the document itself has to be produced, and that is what cannot be proved by mere oral evidence.
So, why is this set up this way? Well, Section 54 has three main objectives. First, it formally accepts oral testimony as a completely valid, powerful way to prove everyday facts. Second, it draws a really hard, distinct boundary between document contents, which have their own strict rules, and all other general facts. And third, it empowers the courts to actually get to the truth by relying on the direct, spoken testimony of living, breathing human beings. Okay, that brings us to Part 3, Section 55 and direct evidence. Now, the law doesn't just let anyone say whatever they want. If Section 54 opens the door to oral evidence, you can think of Section 55 as the strict, non-negotiable bouncer checking everyone's ID at that door. Section 55 makes it absolutely mandatory that oral evidence must be direct. But what does that actually mean in practice? It boils down to three strict conditions, and I want you to notice the heavy emphasis on personal experience here. 1. If a fact could be seen, the testimony must come from the person who saw it with their very own eyes. 2. If a fact could be heard, it's got to be the person who heard it with their own ears. And 3. If it was perceived by literally any other sense, maybe a distinct smell or a physical touch, it must be the person who personally perceived it. The law demands first-hand experience, no exceptions. Let's set the scene again. Imagine the dramatic lighting of a courtroom. Witness A is standing right there in the box, looking directly at the judge and says, "I saw B stealing." This is a brilliant illustration of perfect, admissible evidence under Section 55. Witness A is reporting a visual fact that they personally, directly witnessed. This is the gold standard, direct oral evidence. It's highly reliable, it can survive rigorous cross-examination, and crucially, it lets the judge observe the real-time demeanor of the actual person who experienced the crime. Let's move on to Part 4. We need to talk about hearsay and its exceptions.
This is where we need to build some tension, because honestly, real courtrooms are rarely that straightforward. We're shifting away from the crisp clarity of direct evidence into the really murky, unreliable, and frankly dangerous territory of hearsay. Consider this hypothetical. Witness C takes the stand, swears the oath, and tells the judge, "Well, Your Honor, D told me that B committed the theft." Do you see where the chain breaks? Witness C didn't see the theft. They didn't hear it happen. They're just repeating a story they heard from someone else.
And that right there is the definition of hearsay evidence. Hearsay is a statement made in court by a witness who did not personally perceive the event, but is just passing on what a third party said. It's basically a game of telephone. And under the strict test of Section 55, this testimony completely fails. The court can't properly cross-examine witness C about the actual theft because, well, C wasn't even there. Because of that, as a general rule, hearsay evidence is strictly, unequivocally prohibited in Indian evidence law.
So, the golden rule remains clear. Evidence must be direct. But listen, the law isn't entirely rigid. It understands that human life is messy and complex. So there are a few very specific, situational exceptions where hearsay is actually allowed into the courtroom. These only happen when the circumstances provide a massive guarantee of truth. For example, a dying declaration. The law generally presumes a person isn't going to meet their maker with a lie on their lips. Or res geste, which covers spontaneous statements made in the absolute heat of the moment. And admissions, where a person says something that goes directly against their own self-interest.
Let's transition into Part 5, Landmark Judgments. So the statutes give us the written words, but it's the Supreme Court precedents that breathe real practical life into Sections 54 and 55. Here, we've mapped out 4 absolute foundational cases on direct evidence and hearsay. In Bodh Rajvi State of J&K, the court really drilled down on how to evaluate the credibility and consistency of a direct eyewitness. Then you have State of Rajasthan v. Bhawani, which established a massive principle. Oral evidence cannot be thrown out just because it's oral. If it's credible and fits the circumstances, it carries massive weight. Moving on, the 2011 Supreme Court case Kalyan Kamarga Goy v. Ashutosh Agnatori is basically a masterclass on the exact legal boundaries of hearsay and its exceptions. And finally, Taper v. the Queen. This is a historic 1952 English case, but it's still highly relevant today because of its pristine, flawless explanation distinguishing between direct perception and hearsay.
Now, how do courts handle those exceptions we talked about, specifically res geste? Well, in Gentila Vijayavardhan Rao v. State of AP, the Supreme Court made it clear that if a statement is so deeply tied to the main event that it forms part of the same transaction, it escapes the hearsay ban entirely and becomes admissible. And similarly, in Ratan Singh v. State of HP, the court backed this up, allowing immediate, spontaneous statements made right at the time of the crime to act as a totally valid exception to the strict direct evidence rule of Section 55.
All right, let's head into our final section, the exam summary. We have covered some deep legal ground in this explainer today. Let's synthesize this whole journey into a highly focused, practical takeaway. If you are prepping for a law exam, or you just need a quick mental reference before stepping into a courtroom, this is your ultimate one-liner breakdown. Burn this distinction into your memory. Section 54. Facts can generally be proved by oral evidence, except the contents of documents. Think of it as the door that lets spoken testimony into the room. Section 55. Oral evidence must generally be direct. That is the filter ensuring only first-hand, personally perceived truth makes it to the judge's bench. One establishes the rule, the other demands the directness.
As we wrap up this explainer, I want to leave you with a somewhat provocative question to think about. The Bharatiya Sakshya Adhiniyam of 2023 is our new governing statute. Yet, as we just saw, we are continually relying on Supreme Court judgments from the era of the old Indian Evidence Act of 1872. So, why? Well, it's because while the statutory text itself evolves to match modern times, the fundamental doctrines of justice, the core philosophy of what makes evidence reliable, direct, and truthful, those remain totally timeless. Those old precedents still offer invaluable doctrinal guidance as long as we carefully apply them to our new statutory framework. Keep that in mind the next time you're analyzing a case. Thanks for joining me on this deep dive, and keep seeking that direct truth.